Thanks everybody. Here we go into our next session here at Spring Spokes, and a really outstanding session and a terrific speaker who's joined us at Spokes before. We're going to talk about a lot of different frameworks and regimes, but then focus, of course, on generative AI and of course, generative AI. Most of us are thinking ChatGPT, but for those of us seeing it across the space, you're seeing generative AI in product after product, starting from the marketing perspective, generating images, embedded in a lot of different technologies and a lot of different companies. And we thought it was an important topic to at least start the discussion here at Spokes today. I'm delighted to introduce Karolina Mosasovic, the Deputy Head of Unit, Data Protection for the European Commission. Karolina, we've been lucky to have Karolina as a speaker with us before, and has a depth of knowledge across a number of different important areas that touch on this area. And of course, Sheridan Clemens, who's the VP of Privacy here at Wirewheel. And please welcome them both. And we're going to jump right into a conversation around generative AI. Thank you. If you don't mind, just a moment or so of how you came to run that portfolio. We have students that watch Spokes from around the country, and they always like to hear how somebody came into these positions. So if you don't mind, a moment or so about your background and then
data protection. Well, I am, as you rightly said, just a deputy in the unit dealing with data protection application and or implementation of the GDPR, General Data Protection Regulation in the EU. The Commission is not the enforcer of the General Data Protection Regulation in the EU. These are independent data protection authorities, but we are the policy maker, the Commission, and we are the body which submits the proposals for the two legislators, the Council and the European Parliament. So while we are preparing these proposals, whichever kind of proposals in the European Union which touch upon processing of personal data, these proposals are checked by my unit in order to ensure that we have a harmonized and unified approach to all the solutions which are coming up in all the new acts, be it Data Markets Act, Data Services Act, Data Governance Act, Artificial Intelligence Data Act, and whichever acts we not have, that they all share the same approach as far as data protection, our processing of personal data is concerned. So this is what I do. How did I come to it? It's a little bit different story. Actually, I was working for a very long time as a competition lawyer. I was defending the Commission, representing the Commission in front of the courts, defending our antitrust decisions. And I had a small a trip with WTO, so Commission or European Union before WTO panels and appellate bodies, and then data protection. And this expertise I had from antitrust litigation, fines, and everything was needed while we were finalizing the negotiations of the GDPR.
Oh, that's really interesting. And Karolina, I think I see folks entering the data protection and data privacy field, anti-competition, is a very common path. I think, data in some ways, you've seen certain platforms, it's almost considered, on the verge of a monopoly in certain data elements. And so at least the analogous legal framework is there.
Well, indeed, and we will be speaking about it because Data Markets Act, it's precisely about that, about addressing problems of contestability, fairness of the markets from the point of view of market strength of certain players, precisely due to the amount of data they amassed. But Indeed, I think in general, this antitrust experience litigation, I think it's a very good school, and one of my tasks now, it's to provide for solutions to improve or to streamline further the cooperation between data protection authorities. And while they are enforcing GDPR in cross-border cases, what my predecessors were talking about, and to the dispute resolution mechanism. And as you maybe know, we have we are working now on a legislative proposal concerning precisely legislative tool, which will complement the GDPR and which will provide for means of cooperation of the authorities in cross-border cases, also clarifying issues on position of the complainants, due process rights of companies, controller processors, and indeed beefing up the cooperation or the way the authorities cooperate before they table draft decisions. So this experience I bring very much from the administrative, from the procedure in antitrust cases or
Yeah, no, I can imagine. And there's a lot to talk about today. So I'm looking forward to the discussion, as I'm sure our viewers and colleagues are here today. I did want to give a quick moment for Sheridan, our VP of Privacy. Sheridan, do you mind just giving a few minutes on your background and how did you, what was your history before WireWheel?
Yeah, sure. So prior to WireWheel, I started my career out in information security and primarily helping the federal government and companies in the financial sector implement information security, and landed at the Walt Disney Code very briefly as they started to build out their GDPR compliance. And as I was helping them with data governance and trying to understand how that would relate to GDPR. So I first stepped my toes in, and then afterwards joined Deloitte Consulting and managed implementations of privacy programs across the globe for about 5 or 6 years. And joined WireWheel.
Awesome. All right, well, great. Listen, a lot to talk about. Carolina, I'm going to start. I think it's always important to just sort of lay a basic foundation. And the reason I say this is when we're talking about generative AI, of course, you have to start almost every analysis when you're talking about privacy with GDPR. And there's also now five possible other, I'd call it legislative, regulatory, or proposed legislations that could be relevant. I'm sure I'm missing some, but I'm going to list them off one by one. And I always think it's helpful to just talk about what the focus of these other frameworks are at a high level, and then we can jump into how we think about generative AI. So you mentioned one of them, the Digital Markets Act. And I'm going to run through here the Digital Markets Act, the Data Governance Act, the Digital Services Act, the AI Act, and the Data Act. Okay, so we're going to do one after another. Those are 5 in addition to GDPR. So if I may, let's start with the Digital Markets Act. For those watching here today, we're going to say there's already GDPR. What does the Digital Markets Act cover?
Well, GDPR is about how to process, when and with which tools one can process personal data in the European Union. This is about the obligations of the controllers, processors, and the rights of citizens, and plus the enforcement. Data Markets Act is not about processing of personal data. Data Markets Act addresses different aims, different issues, namely the contestability of the markets and fairness of the markets from the data perspective, and not only personal data, non-personal data also. So it's not about when can I process personal data, on which rights do I have. It's about achieving very much a competition objective of ensuring that markets are open, contestable, that markets entry barriers are being lowered, and that the conditions on the market are fair. What data market does is to impose on very few undertakings certain obligations. Who are these undertakings? The so-called gatekeepers. They are going who are going to be the gatekeepers will be designated by the Commission, and there are very concrete numbers. Huge platforms, generally, there are very few addressees of the Data Markets Act. And they have certain obligations. Let me divide them into do's and don'ts. Don't discriminate. Don't feed yourself out of the data which people, businesses create while using your services. And then which could be subject to further specifications still by the Commission if the gatekeeper wishes so. And a general obligation in Article 5.2, which one concerns the possibility of merging data to which gatekeepers could have access. I don't want to enter too much concerning online advertisement. And then 3 additional obligations in Article 5.2, letter B, C, and D to be precise, which concern the possibility, the condition when a gatekeeper could combine or cross-use data which is generated through or on different so-called core services. So this is what a data market is about. Yeah? How to make it, how to break up this incredible market power certain undertakings have because of the amounts of data they already generated, they amassed, and because of how the data is still being generated while using their core platform services.
So that's really helpful. So the Markets Act we can think of as almost more of an anti-competition focus.
Very much.
It has both personal data and non-personal data, and it's really focused on platforms as specifically defined by the Commission under the terms of the Act.
Exactly. And then, if you want to be very precise, indeed, there are certain tweaks in comparison to the GDPR, only for the gatekeepers. For example, the gatekeepers, in order to combine cross-use the data, the example I just used under Article 5.2, will need to have a consent of the end user. This is narrowing down of a legal basis provided for in Article 6 of the GDPR for the gatekeepers when certain things are being done. Then there is an additional obligation of beefing up as if of portability, right? When data generated through core platform services of the gatekeepers is concerned. So there are some changes, but in general, Data Markets Act is not about how to process data and which are the obligations of the controllers of processes in the light of this fundamental right protection of personal data in the EU.
Got it. So for today's purpose, I'm going to go, we have 4 more to go, and I want to make sure I can save some time for actual discussions about no. For present purposes, I think, fairly speaking, almost everybody in the room was a little stunned about how quickly we all learned about ChatGPT and OpenAI. I think within a day and a half of it hitting, everybody I knew, including family members of mine who don't pay attention to a single thing technologically, were asking about it. And almost every developer I knew had tried it out. Yeah. So for present purposes, I guess it's possible that ChatGPT is on our list that's affected by the Markets Act, but that's a thing we can come to in a bit, it sounds like. You know?
Well, it depends if ChatGPT is a gatekeeper, then yes.
Yeah, in the future, but not, perfect. Okay, the next one is the Governance Act, the Data Governance Act. How do folks think about that?
I think it's, first of all, it does not change anything concerning the legal basis. So everything runs the normal GDPR, and then it just provides for facilities, modalities of sharing the data, public data. Yeah, and solution for data altruism and how is it being construed in Europe. So this possibility to give data, intermediaries there and so on. But this is really an add-on. What is interesting with the Data Governance Act are all the data spaces we are creating all around. So there will be additional acts. For example, to add to your list, for example, now we are working very much, and it's being already negotiated between the Council and the European Parliament, the European health data space. When we are creating this special safe environment so that the sensitive data, the specially protected in the EU health data, can, under specific circumstances, be made available to researchers. So this European health data space addresses, to some extent, the primary use of data, more harmonization on the side of how the data is being collected, or how the patients have access to their health data on the national level. Building there some Windows platform so that it's easier for me to get access to my data, to send this data when I'm in Europe. We have a lot of member states. So when I'm on a vacation in Spain, that my doctor in Spain will get access to my data in Germany, and I had a test made in France, so that they all will have access to this. And so this primary use, harmonization. Then concerning the secondary use, we are building a secure environment to which the hospitals, the clinics and so on will be sending the data. When a researcher makes a request to an authority, which will assess this request, and we will say, okay, under this and that conditions, in the safe data space, you will be able to make your research on the basis of the health data, and you will be taking out only generally results of the research, so that the data, normally already pseudonymized, even in the secure space, will be even more protected. So this is the secondary use which we address. So the health data space. Then the next, what would it be? Data Act.
Yep.
Or Data Services Act.
Well, I would have said Digital Services Act, but
Digital Services Act, it's also not about processing personal data, really. Digital Services Act, it's about responsibilities of the intermediaries in internet. Yeah, so it's their liability, and it's content moderation. This is what Data Services Act is really about. And of course, now, since everything concerns personal data, now somehow there are bits and pieces when this personal data is mentioned. As far as strictly, so a reference to consent, what is profiling, or for example, restrictions of provision of personal advertisement to minors, or while using sensitive data by certain operators. This is,
and when you say intermediaries, can you give an example of an intermediary that you're?
Big internet operators.
Internet service providers and like others who are maybe providing the pipes for the delivery of okay, perfect.
So it's their responsibility for the content which is being streamed, and their liability also. This is what is mainly generated there, regulated there. And aspects of personal data, assessment of personal data, compliance with personal data regulation come in when, for example, in the risk assessment, and very large online platforms or certain operators need to do a risk assessment which concerns all the fundamental rights. And so
that's perfect. Okay, so then before we get to the AI Act, let's go to the Data Act. What is the Data Act?
Data Act is more about, so has several parts. One part, it's about Internet of Things, the first part, which provides for how products placed on the European markets have to be designed, manufactured, including software, so that an additional right or this beefed up portability in Article 5 can be effectively exercised. So it's this is the first part. Maybe I will finish about this first part because it's a very interesting further developed portability, which we did not really see very much taken up from the GDPR, Article 20. So in Article 5 of the Data Act, we opened it up, we detached the obligation, because now under the GDPR, the portability, so porting my data from one controller to another, can happen only under when this controller processes the data under two legal bases, consent and contract. Now in the Data Act, we opened it up, all legal bases. So by Internet of Things, by devices from the Internet of Things, the user, also legal person user, because in Data Act, we address not only personal data, but also non-personal data. This user will ask the data holder, using the language of the GDPR, it would be the controller, to port in real time, immediately, and any kind of data I want him to port to a data recipient or third party, as it's called. I will have a relationship with, if I want to port it to you, with you under the GDPR, you'll need to have the legal basis. I have, of course, my legal basis and relationship with whoever has the data. And then under the Article 5, I just make the request, and the holder, my initial controller, is obliged to send to you any kind of data. It has on me, consent, contract, legitimate interest, which is very interesting because it was not used, and a lot of data under Internet of Things is generated with help. Also, to some extent, probably legal basis of law, vital interest, if at all. So this is how. Then in the Data Act, we have the part on fairness. What we have seen is that certain companies were very reluctant, didn't want to open it up because they said, well, I made all these investments. I want to have, reimbursement. I want somebody to cover up my costs in the creation of this data, in the generation of the data, or that through me, the data was generated. So we are providing there forefront terms, fair and reasonable and non-discriminatory application. Then there's still a part very much contested now during the negotiation between the Council and the European Parliament on access of public authorities to data of private companies. And the last part, it's on cloud services. Only the first part is on Internet of Things. Front, so fairness, which Data Act will be very often attached to the idea of fairness, how to make this to cover the cost of whomever allowed through its services to generate this data, so that we do not stifle the innovation that people still want to prove. So only the first part is Internet of Things, but the three other parts, namely this fairness front, the negotiation contracts between holder and the third party will receive the data, public access, and the switching between cloud services concerns everything, personal, non-personal data, and also then complements in this respect the GDPR.
Well, that was an unbelievably efficient covering of now 4 major acts. And now we come, because they do all touch on these concepts of generative AI. When we've been, and I'm going to come, Sheridan, among one of the things we wanted to talk about was, Italy Data Protection Authority, at least temporarily looking to halt the use of, ChatGPT. I think all of us, when we're using generative AI, we've probably been starting with ChatGPT, and then you expand out the use cases. And for my mind, it's hard for me to even wrap my head around how you think about the generative AI use cases, Carolina, using GDPR and AI Act. So if you don't mind, if you can give just a few minutes on what does the AI Act, which is in draft, what will it add to the GDPR analysis? And then I'm going to, just between the three of us, I'll throw out a couple of hypotheticals that I've seen in ChatGPT, and let's talk about how GDPR plus this draft AI Act would think about these hypotheticals. So if you don't mind, give us a few minutes on what would the AI Act add to the analysis of GDPR under our hypotheticals?
Well, AI Act addresses, by the way, the first horizontal, this kind of legislation in the world, really, addresses questions of placing, putting into use, and using artificial intelligence systems solutions. So it complements the GDPR as far as deployment of artificial intelligence, which touches upon processing of personal data, is concerned, while still adding, that's really nitty-gritties, two additional maybe legal bases for specific solutions, and really addressing these questions of black boxes and indeed prohibiting clearly certain deployment of artificial intelligence. So the whole system of artificial intelligence regulation, it's really, one should imagine a pyramid. On the top, there is a very small box with prohibited uses. What one cannot, how one cannot use the artificial intelligence in the EU. So this risk, because it's all risk-based, which risk is unacceptable. And it would be one which is attached to clear threat to safety, life, and livelihood rights of people. This is this manipulation, subliminal techniques going beyond person's consciousness. So there we can maybe touch upon what you were talking about. This is manipulation of human behavior without people realizing that. This is clearly prohibited. Within this box of prohibited AI is a very interesting box of remote biometric identification, real time for law enforcement purposes, which is allowed under very strict conditions. And actually, these are three cases: missing child, imminent terrorist threat, and very serious crimes. And of course, you can imagine that this, because this is now, it was addressed by the council made those a little bit small changes, added something, has taken something away. Then we are moving to the second box, to the lower box in the pyramid, where we are in the high risks. And here are, artificial intelligence used as components of certain products, which are listed in Annex 2 to the Act, and self-standing use of artificial intelligence systems in Annex 3. And what is there? It's, for example, use of artificial intelligence for educational, vocational training, employment, markets management, access to public services and benefit. Also, again, in law enforcement, when there is an assessment of, for example, the probability that somebody will be reoffending and so on. Migration, asylum, administration of justice, all of this is high risk. And in order to be able to use artificial intelligence in a high risk, certain additional conditions are added. And this is where this addition on the top of the GDPR happens. In particular, far-reaching transparency obligation and also ex-ante approvals.
Do you mind if I jump in with a question? Okay, so now let's come to some use cases for generative AI that make my brain hurt. To be perfectly honest, I put this in the make my brain hurt category. Okay. One of the generative AI technologies, setting aside ChatGPT, that I find fascinating is digital training avatars. Can you guys raise your hand if you've seen one of these things? A digital training avatar? Okay. So these are not human beings, as far as represented in the advertisements, Carolina, This is not a person who lives on the earth. It looks and acts like a person, and they're being used for training purposes. So companies are often using these digital training avatars to train their own teams on how to do something. You can make training videos for your customers on how to do something. And the actual image and the accents and the voice are all generated based on a wide model. And one of the weirdest things to me is you can pick the gender, the race, the accent of the trainer in your own kind of Frankenstein way, okay, for purposes of training. And it's a weird thing. When you see it, the way that it actually generates it, it makes all kinds of ethical questions for me. But let's say I were using this tool, this generative AI tool, to create a trainer or an educational video, and I use it to put it out there. So if I come back to your analogy, okay, so if I go through the legal analysis just purely under GDPR, I am a controller and I'm putting out content, so it's my responsibility as the user of this generative AI to make sure that whatever I put out there, I'm responsible. It's not necessarily the generative AI company that generates the fake human being. That's my starting point because it's a service provider. I literally have no idea, as the user of such a service, I have no idea what images went into creation of the person, of the fake person. I have no idea whether the avatar I'm given, Carolina, is actually 99.9999995 of an actual real person, and 0.5 of some other person. You probably couldn't tell. I don't have any idea what biases went into creation of the image. Like you can imagine that could happen. My job is I generate the AI character, I use it for training purposes, so I'm the controller. And then this generative AI, I guess this character, I have to make sure it's not deceptive or used in a way that would trick the person who's doing the discussion. And are there other things that in an image-based generative AI that me as a user of that service have to analyze under GDPR and the AI Act?
Well, one thing is the GDPR. So probably here under the GDPR, it would be the questions of the rights of whoever created this avatar in order to be able to process the probably personal data of a person who served as an model for the avatar. But there is no personal data of the users that you process, if I understood you in your example correctly.
That's correct. Yeah, the users who are coming to watch it are just consuming the video.
So this is one thing. Now, with the artificial intelligence, what we provide, it's depending on the use. What for do you use this avatar? You have certain ex-ante obligations and approval, or it's prohibited, or ex-ante obligations with approval, or additional transparency obligations to inform the recipient of the service that it is being faced with, it's in contact with artificial intelligence, that it's not a human being in front of it.
So fair thing, and this is under the AI Act, not necessarily GDPR. You're saying if you're using an avatar that's AI generated, you may have to get approval before you use such an avatar. I assume that's from the Data Protection Authority. Is that right?
Oh, well, but why would you? Because here in your example, you are processing the data of just the model. Let's assume the even because you created the example in such a way that it was a personal data of the model of the avatar. You are not processing personal data of nobody else. Or do you want to make an example saying that you created an avatar on the basis of profile, or so that you already profiled the audience so that the avatar would be, the most, the one that would speak, address the audience, or would be the most appealing to the audience?
This is a great question for me. So
these are two different things.
It could be. So like, and again, I don't want to go down too many rabbit because we could be here, but in the example you just gave, right? If I'm using an AI generated image with a consumer who comes to my website, is there off the top of your head an obligation under GDPR? Because basically my consumer on the website is interacting with a generated image that's not a real person. And now imagine, this isn't impossible. In fact, I bet we could do this quickly. Imagine that which avatar you see is generated for you based on who you are that visits the website. So let's say I visited a website and it generated a different avatar for me because I might find them more appealing than for you or for Sheridan. Would that implicate GDPR?
Well,
Or the AI Act?
when you make it so much dependent on me, so probably you're profiling something, you're processing some of my data. So yes, probably first of all, you would need to have the legal basis for it. Even if you do it under legitimate interest, and I do not want to enter into discussion whether you balance correctly and whether you can do that or not, but at least transparency information already under the GDPR will kick in. But let's assume you do not change always the GDPR dependent on really profiling. You have like a broad groups and you just change these avatars. If in the moment when you are in a situation where the audience do not perceive this immediately, when it's not obvious that it's somebody constructed, that it's an artificial intelligence, you need to provide under the artificial intelligence a transparency information to the person you are interacting with artificial intelligence system. So, for example, in deepfakes also, yeah, this is what it's expressly provided for in the proposal of the artificial intelligence. Yeah.
Well, so do you mind
And
if I
then-
keep going? This is interesting. I mean, by the way, if you all have questions, look, as my brain's spinning. When you get, so, you know, for example, you probably users of generative AI will probably have to start at least alerting people, hey, this result that you're seeing is generated by AI. It sounds like that's a condition. But the way I've seen it work already when I'm watching demo videos, you can feed ChatGPT or any of these things, a combination of a query plus data about the requester, and the output of the AI, the output of the generative AI is different based on those two data sets. It's interesting. So now imagine you visit a website. I'm just giving you another hypothetical, okay? You can put in a query to the website. It tells you it's artificial intelligence, but the website is going to feed to ChatGPT profiling information based on observed information. Where I'm located, for example, I'm located in Washington, D.C. in the United States. It might be able to even see what websites I visited before I visited that website, okay? Now, when the query goes in and it generates the output, if the output is a combination of the query plus data about me, then it's an output personalized to me, generated based on AI. So how do you analyze that under?
Well, probably already the GDPR obligations are coming in because your personal data, depending on how hypothetical you went from very high, maybe just the region, to a little bit lower, the pages, to more granular pages you visited before, probably it would be already personal data, then you would be under the obligation under the GDPR. If not, under AI, you would be in any event under the obligation to provide information that somebody, if it's not very clear, obvious, like in video games or spams or whatever, information you are in contact or you have with artificial intelligence.
That's interesting. So that's a pretty broad, interesting disclosure obligation. Now, is this a disclosure obligation that's a GDPR disclosure obligation, or is it a GDPR plus AI Act disclosure obligation? Because the AI Act is not.
All this, the different personal data was processed. You had a legal base and you had to inform. Yeah, so independent of the legal basis, you will have all the obligations stemming from Article 12, 13, 14 of the GDPR. Or if it was non-personal data and you are in the box of artificial intelligence, which is this likely to cause risk or not the prohibited, not ex ante obligation, but just so that people understand it's artificial intelligence obligation from there. So really the division line as personal data was processed, yes or no. If personal data was processed, all is GDPR. If not, at least, if not obvious, AI.
That's interesting. Okay. I'll come at it a different angle now. Okay. Now here's, by the way, this is a ringer set of questions. Before I go on to my next hypothetical, do you all have questions that you want to put? Yeah.
Service provider together. You're offering it like and you don't know whether or not when they generated this, I'm going back to the you don't know whether or not the representation is 99% one person or whatever. But I would think you would have an obligation to do some level of due diligence, difficult thing to do, right? Because at what point, if it's greater than 60% one person, is it actually now identified? So I'm just, my question is specifically, as we go further and further to this, and I don't know that anybody has an answer, but I think this question are very valuable. At what point do you, as a co-controller or processor of the service provided by a third party, have an obligation to verify that they're telling you, according to consent or other legal basis, they got to use pieces that they put together to represent this person?
Honestly, I think that's a great question. And it's similar. It's pretty much what I was trying to go to. I think you phrased it perfectly. If I'm consuming an AI service as part of my product, Carolina, it's really hard to audit anything. I mean, to be honest, and I'm not even sure the services that provide generative AI right now, I would be surprised, maybe they do. I'd be surprised if they provide any kind of warranty about what you're getting out of the model on whether it's 99.95 a single image or 25% or what, because it's generated, right? So what is the obligation of a controls that's consuming an AI-driven service to understand what went in and what came out of the service that you're using and representing? Maybe
controller in the sense of the GDPR or AI user.
Let's call
Because
this
this
an
is-
AI user. How about an
Because,
AI user in
because
this example?
is an easy answer. The artificial intelligence regulation addresses it in Title 3, Chapter 3. And we distinguish between obligations for providers of AI solutions and techniques and AI users. AI providers should, for example, have to establish and implement quality management system in its organization, draw up and keep up-to-date technical documentation, undergo conformity assessment and potential reassessment of the system, register standalone AI system in the EU database on the basis of the obligations which are listed in Annex 3. Sign declaration of conformity and FXC marking, conduct post-market monitoring, report serious incidents and malfunctioning leading to breaches to fundamental rights, and collaborate with market surveillance authorities. These are the providers. The users, which operate high-risk IA systems in accord, they have to operate these systems in accordance with the instruction of use, ensure human oversight and monitoring operations for possible risks, keep automatically generated logs, inform any serious incident and malfunctioning to the provider or distributor, and of course, if there is personal data, GDPR continues to apply. There is no carve-out of the GDPR there. These are additional obligation, because I think sometimes we forget that artificial intelligence is a part of these 2 points, and I'll maybe come to it, not about regulating processing of personal data. It's a product safety regulation. Yeah, it regulates how and to ensure safety of products which are sold or offered on the EU territory.
Well, again,
Yeah, and
that's,
there's two additional things
yeah.
just allow me, because I was trying to come to it. It's really this, what I was talking about, this additional legal base. So where does it tweak on the GDPR? As far as actually more a law enforcement directive, which is something that allows law enforcement authorities to process personal data. And there's a change as far as this use of a remote biometric identification system real time is possible by law enforcement authorities. So there we have a change, no? Where I said for missing child, terror, imminent terrorist attack, and so on. Another thing is when this possibility of or let me call it differently, possibility to process even sensitive data in order to check whether IA systems do not lead to biases, if it's strictly necessary. So there you have a change into the GDPR additional legal basis, a part of this complementation with the transparency obligations going beyond the GDPR.
I mean, that was a lot. Again, you've covered a tremendous amount for us. I want to sort of pivot for a moment because it does get to enforcement for a minute, Carolina, on all of the subjects. Sheridan, you know, we noted at the beginning, Italy, the Italian Data Protection Authority, at least temporarily ban the use of ChatGPT. And it covers, I think, a lot of the subjects, Carolina. We'll also give Carolina a little break here. Do you mind talking about that and what came up from that decision?
Yeah, so it's pretty straightforward. Italy was very concerned that ChatGPT doesn't get legitimate interest from users when they're gathering and scraping data across the web and potentially personal information as they're using it, right? And so under GDPR, they're saying you don't have legitimate interest to collect and also process that information. And then the secondary concern that they had was that it doesn't do enough to protect children or underage users from being exposed to information that isn't commiserate to their level of maturity, right? So I mean, Carolyn, I'd love to hear from your perspective, like, does the AI Act do anything where, in this case, there's a lot of consternation about whether Italy should have stepped in, and I'm not asking you to opine on that, but has there been any action towards approaching AI from the perspective of providing some better understandings of what might constitute legitimate interest?
Well, I'm not sure I understand the question, because if, as I said, and a part of these 2 points where I insisted on Article 10, the change to the law enforcement directive and additional possibility to process sensitive data for in very specific situation, AI does not address really any ground under the GDPR. So I'm not sure I understand the question. How does it affect balancing or legitimate interest under 6.1F GDPR? Maybe I missed there something.
No.
Well, I think that balancing and the application of the GDPR is already allows already for taking into account all these considerations without the need to go back to this product safety regulation, yeah, because all these considerations impact on fundamental rights and so on is already embedded in the balancing test, which which is necessary in order to be able to avail oneself of the 6.1F. If you want, well, one could develop the argument if something is prohibited under AI or a certain deployment of artificial intelligence is assessed to be by the Commission Annex 3 and high risk, whether this should not be taken into consideration. Yes, but only in such way. I would also think that looking at the list of Annex 3 on this deployment, in which situations standalone artificial intelligence systems are amounting to high risk, I do not really think how this uses would be easily a priori imaginable under legitimate interest. We were speaking about employment, assessment of social benefits, law enforcement, biometric evaluations, and so on. This is nothing that one can do a priori under legitimate interest. So I do not. I'm not sure I understand the question.
Well, listen, I mean, I knew we were going to run out of time. I just want to make sure, are there any other questions on the subjects? We covered in a tour de force today, Carolina, the DMA, the DGA, the DSA, the AI Act, the Data Act, and GDPR as it applies to
And the European health data.
yeah, exactly. European health data and GDPR, all as relates to generative AI. And I'm left with a couple of big takeaways. One is, if we're using generative AI, especially in Europe, we should definitely start putting up some disclosures, not we, but everybody, that, hey, you are interacting with AI. Second, if we're combining general purpose generative AI with any kind of signal from the person that is potentially identifiable to the signal to the person, you're probably dealing with a high risk use case pretty quickly, because it's the processing of personal data combined with a generative AI service. And it's one that we have to pay particular attention to.
There would, if you allow me,
Yeah,
really
yeah.
specific uses, not Annex 3. It's not
Everything.
Because it was for us very important in this artificial intelligence regulation to strike a balance between, you know, to have this proportionality of the regulation and to not to stifle innovation. So that it's the reason this is risk-based. So the question is, what are you going to use it for?
That makes a ton of sense. So context will matter. Third, if you're the consumer of an AI service, you do have certain obligations along the way, and that's an important principle. It's one that we should look for. The providers of the AI services have their own obligations that are significant. To be honest, I don't know if I were the consumer of an AI, if I wanted to use an AI service, is there a place where somebody goes to see that whether the provider has registered and done everything they're supposed to do in the EU? Like, how would one know if they're a...
Yes, the obligations of high risks AI providers include the registration of standalone AI systems. When they are a component, they are already regulated by other pieces of EU legislation.
Okay.
Yeah, and there they are subject to third-party compatibility assessment in any event.
Got it. So I think, you know, we have folks from the investment world here who I know are investing in generative AI. There's some obligations your generative AI companies really do need to be taking to be able to do business in Europe. That was an important set of points that you covered today. So if there are no other questions, Caroline, I want to thank you. It was a fantastic summary on a lot of different fronts. We look forward to having you join us again. And we're going to take a quick 5-minute break, and then we'll be back with our privacy predictions panel. Thank you again.